Mr. Chairman, we are live.
Okay, will you call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams.
Here.
Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Zwanitzer.
Excused.
Chairman Olson.
Here. Okay. That's 8 present, 1 excused. Representative Swanser's on his way. Representative Bear brings us House Bill 210. I want to start by, I've already told you this, Representative Bear, but I do want to again apologize to you for the tardiness of your bill. This is a good bill, and it was assigned to us on March 5th, and it literally fell into my crack, and I lost it. And I didn't realize I had this bill, thought we got all the House bills out. But thankfully, Representative Bear came to me and said, "Hey, when are you going to hear my bill?" And I said, "What are you talking about?" Talked to the speaker, it hasn't been assigned to me. And then sure enough, it had been assigned to me. So apologize for that, Representative Bear, but you're here now and we've got your bill in front of us. So present your bill, please.
Thank you, Mr. Chairman, and appreciate that. This particular bill is the result of a victims advocacy group pointing out to me that there are statutes here in Wyoming that just don't really, they're not up to muster with the statutes in the same area in other states. So this is an effort to bring Wyoming statutes up to date with those of other states dealing with this particular issue. So the intent of this bill actually is to create better protections and more avenues for assistance for victims of this crime. An example of how this bill would affect children in Wyoming is that, generally speaking, children and other victims, adult victims, feel a guilt when they're involved with this particular crime, even though they're the victim. And if our statutes are such that there's a chance of prosecution of this victim, we add to that element of guilt. And the problem really lies in the fact that this guilt keeps victims from coming forward and reporting the crime. And so there may be a great deal of crime in our state that we're just not aware of. We do know in other states it's a pretty prevalent problem. It seems to be minor if you look at statistics in Wyoming, and hopefully that is true. But I expect that as our society goes down the path it's going, we're going to continue to see more and more of this crime. And I feel it's important that we get our statutes prepared to deal with that and protect these victims of this crime. So with that, I'll go through the bill. On the page 1 at the bottom, you'll see section 62708 is Wyoming statutes dealing with victim legal defenses. Going on to page 2, in paragraph A, here we're adding the definition of human trafficking that a minor will be considered a victim and will shield them from prosecution. In paragraph B, we expand the scope of available assistance to children. The language provides that a child would be considered a neglected child under the Federal Child Protection Act, even if their parent was the one that perpetrated the crime on the child. So we're creating an opportunity for DFS to provide assistance for these victims, whether the parent was involved with the crime or whether the parent was innocent. At this time, I'm going to share with you the amendment that I brought. Each of you should have a copy of that. It's a very simple amendment. This was brought to us by the Attorney General's office, and it had to do with our language in the bill currently creating a little bit of confusion about the word neglect and abused. And so we're basically, at this time, we're deleting abused on line 12 and inserting neglected in its place. We're also striking the language after the word act in line 16 and all of line 17. What this does is it makes this bill align up with the Child Protection Act federal code. And that we had the language a little backwards there, and that creates less confusion if we get this amendment passed. So this change is a result, as I said, of the Attorney General's office pointing out that we had that confusing language there. Then moving on, 6-4-101, we prevent the prosecution of minors for prostitution. Then on page 3, under definitions, Romanet 2, we add the language referencing the fact that human trafficking against a minor is prohibited. And specifically, this is found in Title 6, Chapter 2, Article 706 of Wyoming statute. So it's a fairly simple bill. And with that, Mr. Chairman, I humbly ask for your favorable consideration of the bill, and I stand for questions.
Vice Chairman Washington.
Thank you, Mr. Chairman. I like your bill, but I have a concern. Imagine a scenario where some high school students decide to create their own sex market. Okay. They're not being trafficked. They don't have anyone coercing or forcing them into that. It's a business decision. Okay. I believe that the vast majority of minors who get involved in commercial sex activity are in fact being trafficked, far and away. But I don't think that the scenario that I'm suggesting is impossible. And if we send a message that there is no consequence if some high school students decide to start doing this, right? What I would suggest, and I just want to run by you, see what you think about this, would be if the presumption that minors are being trafficked would be the default condition, but still carve out at least a window that upon showing of evidence to a court, some prosecution might still be possible. That if we can show a court that no trafficking is taking place, that this was a voluntary commercial enterprise by these minors, that they could still be held accountable in some way. Your thoughts?
Representative Bear.
Thank you, Mr. Chairman. And that's a great question, Representative Washit. My personal opinion is that there's still a victim in that situation. But that's my personal opinion. And I think that as we hear testimony from the advocacy group, they may have a specific answer to whether that would be an issue, having that in statute. I would find that a friendly amendment to have that carve out, if you will. But I would be concerned that, you know, it could send the wrong message. And that's my effort here, is to make sure that we're sending a message for the preponderance of the issues, as you mentioned. And I hope that we would always make efforts to deal with the generalities rather than the exceptions. And that would be my concern. It would be a friendly amendment to do that carve out, in my opinion, even though. Thank you.
Questions? Okay. Thank you, Representative Bear. Let's go to the Attorney General's office. Kara.
You sound so excited to hear from me, Chairman Wilson.
Sorry.
It is, Brian.
Kara, let's please hear from you.
Morning, Kara Chambers, Division of Victim Services. I am here as the chair of the Attorney General's Human Trafficking Task Force, which we have run since 2016. You know, mostly would like to have a conversation and answer questions. But if I may speak to Representative Washit's concerns, one thing that I want to make really clear is sex with children is always illegal. It has been for a long time. So I don't see a scenario where there wouldn't be an avenue for criminal prosecution. You know, you use the term enterprise or criminal enterprise, which is of course what trafficking statutes are aimed at getting after. You know, we have prostitution, we have solicitation statutes, we have child abuse child neglect, child endangerment, sexual exploitation of a minor statutes on the books already. And we understand that this bill is attempting to enhance some provisions that are in the law already. But I just wanted to clarify for Representative Washit that yes, there would be other schemes under which that sort of activity could be held accountable.
Representative Washit.
Thank you, Mr. Chairman. Ms. Chambers, could you be more specific? If we classify under this bill that prostitution is only a crime for people over age 18, what statute would you think we would utilize to hold minors, let's say 17-year-old, who voluntarily engages in commercial sex activity, whether it's an enterprise or not, but voluntarily enters into this activity? What statute would you think we would prosecute that 17-year-old under?
Ms. Chambers.
Chairman Olson, Representative Washit, again, it gets fuzzy with the age of consent. But again, sexual exploitation of a minor is illegal under our Title VI statutes. I don't have the exact reference at the tip of my tongue. Again, I don't know of many instances where a minor would be prosecuted for prostitution regardless because of those other avenues. Again, we'd be looking at how that 17-year-old got into that circumstance. Because again, I think there's still sort of an understanding that, it's not the most ideal way to make money. And we'd be concerned about what sort of supervision that 17, 16-year-old had. But if that is a concern with this statute, I think Representative Baer has addressed that. If you would like to go back to the language as it exists, the prostitution statutes as they exist that don't carve out that 18. Again, I don't know. And luckily you have at your disposal a prosecutor sitting right next to you who could perhaps address how she would handle a scenario like that. But, again, I believe they would go under the other child sexual exploitation statutes of some capacity. But then again, that would be going after the person who's the buyer. I think you would probably look at that child as a child in need of supervision, certainly. And I'm admittedly not as well versed in juvenile law and juvenile court because it is so separate and so unique.
Thank you, Mr. Chair. Thank you, Ms. Chambers. I didn't bring my statute book this morning. The sexual exploitation of children is actually what is colloquially called child porn. I don't think that's really where we're at here. So my question would be to you is to go back to what Representative Washit proposed and discuss that. Why not? He gave a scenario, and we certainly know that sometimes it can be a minor that's engaged in the illicit conduct, and that's what he's trying to address. So what would be the problem with having, as he suggested, considering it a rebuttable presumption instead of just flat saying any minor engaged in any of the sex act shall be considered a victim? It seemed to me a pretty good common sense solution to have a rebuttable presumption. And I don't know if I heard you address that. Can you, if you have an opinion on, tell us why that wouldn't be a solution to some of the scenarios that he presented.
Ms. Chambers.
Chairman, Representative. So I have to be clear, and I want to be very supportive of Representative Baer, but you're putting him in a position of defending some language to a statute that we didn't propose, that we didn't necessarily think was necessary. And I don't mean that in a bad way. I'm just saying this was something that was brought by a group in Sheridan who are members of the task force and wanted to have our laws mirror other state laws. And I was very late to the game in seeing a draft of this. So again, when we worked on this legislation in 2013, we tried to be very comprehensive and tried to make sure that, there are safe harbor provisions. There are already provisions that if someone is deemed a victim, that they will not be prosecuted for human trafficking. And that's for both children and adults. The presumption is that, especially with a child, because there is an interesting component in our law and many laws when it comes to child sex trafficking, and in that the definition of human trafficking on the federal level and the definition in most states is that the difference between prostitution and trafficking is that there's this element of force, fraud, and coercion. It's the criminal enterprise of the trafficker who is directing the activities for either forced labor or sexual servitude, and that's how our statutes define it. We have a subcomponent for the child sex trafficking that says, look, no coercion is needed because they are presumptively a victim by virtue of their age. They're children. They cannot, again, sex with children, always illegal. So again, it's hard for me to be the one to explain where this language came from, because I was not involved in that drafting. I understand what they're trying to get at. I understand, ultimately our office has taken a position that this bill does no harm. I think it's always a good thing to understand that this is a very dangerous scenario for youth, and it certainly sets youth up for future exploitation and victimization. It creates a huge vulnerability, but I can't really speak to that exact language and the thoughts behind it, because I didn't create it. I wasn't involved in the crafting of it. Again, I understand the thought, but you're right. We typically treat children in this situation always as a victim. In fact, we treat adults in these scenarios, in these sting operations, as victims. And what I hear from law enforcement task force members is, and this is with the adults, is that it's very hard for even the adults to identify as a victim. So if anything, the real life scenario is law enforcement and victim services like myself are looking at these individuals as a victim. They're reluctant to self-identify as a victim. Different story with the children. It's just a different scenario with children.
Ms. Chambers, is the rest of your office just here for to answer questions, or does your office have additional testimony?
You mean myself or other members?
Is Ms. Schilling not with your office?
No, she is not. She's with the Department.
She's with the Department of Family Services.
Yes.
All right. Get all you agencies confused. There's so many.
It's fine. Chairman, I will be available for any questions or concerns that may come up throughout the course of this. I think we should have a conversation, but I do know that there are other agencies, and I am aware of some practitioners in the field from Teton Youth and Family Services who plan to testify as well. So I will.
Excellent.
Background for now.
Thank you. Let's go to Ms. Schilling.
Mr. Chairman.
Not from the Attorney General's office, but from the Department of Family Services, which are
Mr. Chairman.
different agencies.
Kara, would really ask a question of Ms. Chambers.
You'd like to ask Ms. Chambers a question?
I would, Mr. Chairman, if that's appropriate.
She's back.
Okay. Go ahead.
Mr. Chairman, thank you, Ms. Chambers. Appreciate it. So I do want to try to dive deeper into this conversation of minors who commit commercial sex acts on their own accord. I think that them creating their own sex ring is maybe a little less plausible, but I think a very plausible scenario is that two kids who are within the age of consent have sex with each other, decide to film it and put it on the internet. I think under the definition of commercial sex act that this applies. If they were found out, is it possible that they would be put into protective services because of that, based on this language, Ms. Chambers?
Ms. Chambers.
Chairman, Representative Yin. Again, you're implicating a whole host of other statutes. I suppose child pornography being right at the top of my head. Yes, I think we would look at anyone under the age of 18 as definitely a child in need of supervision or a victim in some other capacity. But interestingly enough, perhaps Lindsay Schilling, who is with the Department of Family Services, who does have, again, I mentioned that I'm not as well versed in that juvenile world, because when they're victims and involved with family, they would more apt to be involved with family services. So I appreciate the question, but I would actually defer to Ms. Schilling on how they would handle that. We would, again, a lot of other issues with that scenario.
And see, Representative Yin, you thought I was just ignoring you. I knew that your question was for Ms. Schilling, and I knew she was next.
Thank you, Mr. Chairman.
All right. Thanks, Ms. Chambers. Ms. Schilling.
Thank you. Good morning, Chairman and members of the committee. That's actually a specific question I'll have to take back to our policy team. So if I could follow up with you shortly after this meeting, I'd be happy to do that. In general, our interest in this bill is really related to the proposed changes in B on page 2, lines 11 through 14. And really just to confirm what had been noted in the presentation of the bill, it does expand the type of cases that DFS would normally be involved with. Under our current infrastructure, these types of situations, if the perpetrator is not a caretaker, those types of referrals would be rejected by DFS. So this just does open up those processes to be available for situations where potentially the perpetrator is not a caretaker and in relation to that particular child. So certainly a policy decision for the committee, but we don't have any major concerns about what's being proposed.
Ms. Schilling, I don't think Representative Yin's question is a policy question. It's a legal question. Maybe it would be, I guess we have the Attorney General's office, but we don't apparently have the Attorney General who represents the Department of Family Services, which would be more versed in those statutes and possibly able to answer Representative Yin's question. I don't know if that's possible, Kara, to tie someone in to get his question answered. Could we do that?
Sir, I can certainly try to do that.
Okay, let's try that. Questions for Ms. Schilling? No, all right. Thank you, Ms. Schilling. Okay. Do I have any other agencies wishing to testify on House Bill 210? I don't think I do. Of course, I have folks in the panelists, attendees, excuse me, online, but I don't think I have any other agencies, do I?
Mr. Chairman, I don't believe we have any other agencies for this bill.
All right. Let's go ahead and bring in Ashley Garcia. And then we'll do Terry, you're on deck next. All right, Ashley, you can go ahead and turn on your camera and introduce yourself to us. If you represent an organization, please let us know and provide us with your testimony.
Hi, so I'm Ashley Garcia and I'm actually with Terry Markham, who's with Uprising. Is there any way we can bring her in with me?
Yep, she's, we just dropped her in the room. Terry, you can turn on your camera. And
hi, good morning.
go ahead and introduce yourself, and then however you guys want to proceed, whoever wants to talk or you both want to talk, preferably not at the same time.
Well, I'm Terry Markham. I'm the executive director of Uprising. We're a nonprofit based out of Sheridan. I've been doing anti-human trafficking work in Wyoming for about 3 years now since I moved here. And before that, I did this work in Texas. I think what a lot of the conversations are revolving around now, we're getting a little in the weeds, but we've got to remember at the end of the day, a minor cannot legally consent to a commercial sex act. And a commercial sex act is when they're having sex in exchange for something of value. So I think like, if I can address the last question, like with the instance of the pornography, if we had 2 minors who engaged in creating pornography, they put it out on the internet to try to sell it or make a profit off of it. In that case, under this bill, what we're trying to say is no, the minors would not be legally prosecuted and held accountable because they legally cannot consent to do that. What we would do is we would look at the buyers who are buying that video, and we would try to prosecute a human trafficking offense for those buyers. Now, there is no actual trafficker in this scenario because a big part of what this bill does, the most important part, in our opinion, is it removes the need for a third party because we know at the end of the day, minors legally cannot consent to commercial sex act. So instead, we would look at those buyers and doing a trafficking offense on those buyers. And then what would happen with the minors, instead of taking them through a bunch of legal ramifications that can, potentially have really harmful effects on the rest of their life, what we would do is try to get them access to services instead. Because at the end of the day, if we have minors who are legally or who are voluntarily engaging in commercial sex, there's still something wrong. We know that minors engaging in commercial sex have really high instances of vulnerabilities. So there was something under the surface that's happening that we need to look at that is way more important than trying to charge them with prostitution. We want to try to get them services that are going to help put them on a better track for the rest of their lives, not something that's going to potentially drop them into a cycle of exploitation and a cycle of just failure for the rest of their lives. So I'm not sure if that answers your question well enough or not, but I hope that it's kind of clear. It's the same thing with a potential ring of commercial sex that a group of teenagers decided to engage in. It's the same thing. These are young people with underdeveloped brains who likely have a whole host of other vulnerabilities if they are willing to engage in this. And I think when you hear from Ashley in a minute, Ashley is a survivor of domestic minor sex trafficking. I think she can attest to the fact that a lot of times, yeah, maybe when the kids are young, they think that they're voluntarily doing something, but there's usually a whole bunch of stuff under the surface that's really pushing them towards that decision. So even in that case, again, we would look at who's buying sex from this ring of teenagers, and we would try to get human trafficking offenses on that. And then we would try to get those teenagers access to good services to get them back on the right track, and to address all those underlying vulnerabilities that they likely have. A couple things that weren't brought up, but also are why it's really important to remove that need for the third party is, we have minors who also, like, for instance, homeless youth, where their vulnerability is so great that it's really easy for them to get directly approached by a buyer, be offered like food or shelter, and they engage in that commercial sex because they need to survive. In fact, we call it survival sex. But that still doesn't make them a perpetrator or a prostitute. Legally, they cannot be a prostitute because they can't consent to commercial sex. They are still a victim. And it's the same thing in that case. We want to try to prosecute the buyers of sex in the absence of that trafficker. And we want to try to get the youth the services that they need. And someone else mentioned it at the very beginning. I think it was Representative Bear, who also pointed out a really important fact is that a lot of youth and adults, they don't recognize their victim status either. It can be 10 plus years down the road before they realize what they went through was actually trafficking. We also have victims who have these really strong trauma bonds with traffickers, and we need this language because a lot of times you also might have minors who aren't going to identify that they had a third party, even if there was a third party, and we still want to be able to prosecute those buyers, prosecute a trafficker if there is one, and get that youth the services they need. What's really important in this bill is that ability to get youth services and to not prosecute them for prostitution charges. Doing that at this point is really, it's just kind of archaic. There's not really states that are doing that anymore. The federal law doesn't do that. And in Wyoming, we really just want to get our statute up to snuff a little bit because through Uprising and through the task force and several other organizations and efforts in the state, what we know is that over the past few years, we've had a pretty good increase in training around the state and awareness education and prevention education, law enforcement training. And so even though we might not be seeing a lot of these cases at this point, they're coming because we know with this increase in education, the direct result is going to be more disclosures, more victim advocates, law enforcement, healthcare workers being able to identify a trafficking victim that might have slipped through the cracks before. And it's going to be more people in the community who are aware and potentially noticing more and calling in those tips. So we want to get these statutes passed now so that we're prepared for what we know is going to be coming. And I'll pass it over to Ashley now.
Hi.
Well, hold on, Ashley. We
Okay.
can hear from you, but before you do that, let's make sure we don't have any questions for Terry. Questions for Terry. Representative Yin.
Thank you, Mr. Chairman. Ms. Markham, I appreciate the public comment. So again, my concern is, I think it's a great idea to be able to figure out how we can prosecute people who buy child pornography, people who engage in commercial sex acts with children. I mean, clearly that's a very bad thing and we need to deal with it. My concern is that when it's two minors, 16, 17, they're within the age of consent, they sell it themselves. If that puts them at risk on page 2 with the new language in line 12, plus we're with the existing language as well, right? If they're a victim of human trafficking and a minor, we're saying that they're a child in need of supervision. Does that mean that they're going to get removed from their home if they do this on their own? And that's ultimately my concern with the bill. I mean, I like the intent. I just want to figure out how we can fix it without messing up people's homes unnecessarily. Thank you.
Ms. Markham.
That's actually my concern as well. I believe that the ideal way that we would formulate this bill is that they would be referred to human trafficking victim services. The problem is we don't really have any human trafficking specific victim services in Wyoming yet at this point. And so, John, you might have to correct me if I'm wrong, but I think one of the reasons we landed on altering that to include that piece was because we needed to go with what we had at this point. And I don't really know how the law works well enough to know, but I'm not sure if that would be something that would be up to the discretion of the court. But that is the area that I also feel is not the greatest in this bill, but we've got to sort of start with what we have. And as the state continues to do more, and if we eventually do see more of these cases, I think then the need for more specific services would come about naturally. And as those are enacted, then we would, of course, amend this to include them going to human trafficking specific victim services, which would be the ideal situation.
Ms. Markham, when's the last time that a minor who was trafficked in Wyoming was prosecuted as a prostitute?
I don't think that we've ever had a minor prosecuted. I'm not really sure. In Wyoming, I believe so far, all human trafficking related cases that have been prosecuted have been mostly at the pimp controlled trafficking as a result of a sting operation done by law enforcement. And in those cases, all of the people had crossed state lines. And so they were able to send those cases federally. What we're trying to do is get ahead of it and prepare, because for instance, we have a prosecutor training that is in the works coming up this year. We are about to engage next month in our 3rd law enforcement training, where officers will actually be building a case and running an operation at the end of it. And so we're trying to get ahead of it and be prepared for when those cases come. But so far, I don't think we've really been seeing any of those cases, so I can't speak to that very well.
Any other questions for Ms. Markham? All right, Ms. Garcia,
Thank you.
please share your story.
Okay, thank you. My name is Ashley Garcia. I volunteer with Uprising and have for almost a year now. I was a victim of trafficking at 17 when I lived in Casper, Wyoming. And I guess this bill is important for me because as a teenager, at 17, obviously I was still a minor, but at that age, I thought I, was doing things on my own, and I thought that I was consenting to things, and I thought that I knew what I was doing. But at 17, your brain is not fully developed, and there's no possible way, which is why we have the law that states that minors cannot consent to sex, because even at 17, when they think that they can, they just don't have the brain capacity and maturity to really consent to that. And I think it's really important to, rather than tell them that they're doing something wrong and prosecute them, to provide them with the resources that they need and help them understand, that there's other ways around that, and that sex isn't the only way for things. And it's not something that, I can only imagine being a victim myself, having been prosecuted for that and having to be labeled the rest of my life as, a prostitute or somebody who is providing sex for money, especially in my situation. I was manipulated by an older boyfriend, and again, I thought that I was consenting at first, and it turned into not being consent at all. I was actually kept in a house against my will and sold until I escaped after almost 3 weeks. But even with that extreme of a situation, I still didn't recognize that I had been a victim of trafficking, because I didn't have access to resources and services that would help me through that situation. And so I really just dealt with it on my own and didn't really know what it was for a decade. And now that I do know, I think it's really important that this, bills like this are the groundwork to making sure that this doesn't happen in the future, especially with the way the internet is now, and the easy availability that teens do have to upload a video of themselves online. They don't have that knowledge to know that what they're doing has such bigger consequences. And I think that bills like this are where we start to get in the right direction.
Questions for Ms. Garcia? Ms. Garcia, we appreciate you sharing your testimony. Thank you.
Thank you.
Ms. Chambers, did you find anyone for us? Or, I think Representative Yin's question continues to linger out there, and I saw your hand come up.
We are working on getting Jill Kuchera from the law office on. But if I may, I wanted to point out something to add on to Ms. Markham's testimony. Again, Ms. Markham works with Uprising. They're an organization not funded through families or through our agency, but We work very closely with them to provide training and advocacy. If you look at the existing statute, if you go to page 2 and lines 11 through, the language that already exists was to deem juveniles in this situation either a CHINS or under the Child Protection Act. And that was because, as she mentioned, there is a lack of appropriate services for children in the victim services realm. For example, unless you're an emancipated minor, you cannot, independent of an adult or guardian, go to a domestic violence sexual assault shelter program. So, trying to create services for victims within our existing infrastructure in our state. I can tell you that of the child victims that have been interdicted through law enforcement, child human trafficking victims, most of them have been prosecuted federally. All of the children that I'm aware of, and it's a very small number, we do see more of this over the age of 18, candidly, were returned to their home states, which typically had more robust services. But I just wanted to point out that the language that already exists in law would invoke the CHINS Act and the Child Protection Act, because we need to get these victims services. And so with that, I believe we're working diligently to get Ms. Kuchera.
Mr. Chairman, if I may.
Sure, Representative Bear.
Thank you, Mr. Chairman. Representative Yin, you bring up a great point, and really this particular language is addressing that very issue of parents that are not the perpetrators being able to be involved with the help that DFS provides. So that was the specific language. And I think Ms. Schilling might be able to confirm that for you in particular, but we were very careful to make sure that we could include parents who had this happen to their children, but were not part of the issue. It just either happened in a way that they were not aware of, or they just weren't involved. So I believe the intent is to not take them away from that type of a parent, but to get them services in that particular situation. Obviously, if the parents are the perpetrators, which is more common than not in these situations, we're going to get them away from those types of parents. And that's the essence of the bill here. In general, I'd like to speak to the committee about what's been happening in the past. And it really is just common sense. And our legal services and our agencies have been doing an excellent job of just using common sense and taking care of things. So the question is, do we need a bill or to change our statutes to go along with that common sense? And I would say yes, because there may come a day when common sense isn't used in a particular situation. And we don't want our victim in that situation to suffer because the statutes didn't direct law enforcement and our agencies to help in the proper way. And so that's why this bill, I believe, is very important. Thank you.
Do we have Ms. Kuchera?
Yes, Chairman Olson.
You want to introduce yourself?
Yes, I am Jill Kuchera from the Wyoming Attorney General's Office. I'm a Senior Assistant Attorney General. I represent the Department of Family Services.
Excellent. Are you up to speed with Representative Yin's question? You need to hear, I can make him repeat it again.
That would be great if you could, Chairman Olson.
All right, Representative Yin, fire away.
So, Ms. Kuchera, I mean, I think ultimately it may just be not having enough knowledge about the CHINS Act and the Child Protection Act. But my concern with the bill is, does this risk if two minors within the age of consent decide to sell a videotape of them having sex, which would, I believe, be classified as a commercial sex act in our definition, with the language on page 2, lines 11 through 17, would that risk them ever being removed from their home because of it?
And I'm just trying to get over to the bill detail. And can you reference me the Representative Yin, the particular section?
Yes. So it's page 2, lines 11 through 17. It's the victim of human trafficking who is a minor shall be deemed a neglected, well, with the amendment, a neglected child under the Child Protection Act, and as a child in need of supervision in accordance with the CHINS Act.
Okay, and your scenario, Representative Yen, is two minors who place a video of a sexual act on the internet.
And want to sell it. So I think it would be classified as a commercial sex act.
Okay,
Possibly even sell it to other minors.
Possibly, yes.
possibly sell it to other minors. So based on that scenario, it is possible, even with the language in the bill, that might be treated as a delinquent act under the delinquency statutes, just depending on the circumstances. If those two minors were taking that act because someone else was trafficking them, then it would fit under the provisions in your bill. The choice of how to deal with that would be with the county prosecutor or district attorney, not necessarily the Department of Family Services.
Representative Yin.
Mr. Chairman, thank you. So I mean, I think to clarify, in the new language, we're saying that as long as they commit a commercial sex act, they're going to be a victim of human trafficking, which would seem to invoke the section below it, saying that they would have to be deemed a child in need of supervision. So again, my concern is what maybe in the CHINS Act, is there other things other than removing a child from the home, or what is the risk of a child being removed from the home in that scenario?
Okay, just generally under the Child in Need of Supervision Act, Mr. Chairman and Representative Yin, a petition can be filed alleging that a child is a child in need of supervision under the CHINS Act. It doesn't necessitate necessarily removal from the home. Removal from the home is a determination made by the juvenile court with respect to the situation and whether the child needs to be removed from the home because there is a danger to the child to be in the home or a danger to the public for the child to remain in the home. So just the fact that a petition is filed under the CHINS Act, or indeed under the Delinquency Act or the Child Protection Act, doesn't automatically result in a removal from the home.
And Ms. Q Chair, I think that's important what you just said, because this is a shall with respect to how we define the child in Representative Yin's, or children in Representative Yin's scenario. So there's no deference to the Department of Family Services. I think that they have to, I guess my question is, because the child shall be deemed abused, if this comes to the attention of the department must file the petition, I think is what you're saying. And then it's really up to the court. And of course, the court could determine, well, these were just two minors. We're not going to take, the parent had nothing to do with this. We're not going to take the child out of the home. But I think that's really Representative Yin's question. And it sounds to me like your office would be required to file a petition knowing that the child is by definition abused.
And Chairman Olson, to clarify, the Department of Family Services does not file petitions under the Child Protection Act, the CHINS statute, and the Delinquency Act. The determination as to whether or not to file a petition alleging neglect is the county attorney or district attorney.
Okay.
And so that would be the entity who, under your language, would have to file the petition.
I see. So they would actually have prosecutorial discretion on whether to, I mean, whether the statute was actually invoked or not.
And Chairman Olson, yes, under the Chin statute, the Child Protection Act, and the delinquency statute, it is prosecutorial discretion as to whether or not to file a petition. So, for example, if a parent requested a Chin petition be filed, it would still be the prosecutor's determination as to whether or not to file that. Or if the department presented a prosecutor with information and requested that the prosecutor look at filing a neglect petition, again, it would be the prosecutor who would make that determination under Title 14.
Representative Washington.
Thank you, Mr. Chairman. Appreciate you joining this conversation. It got more complicated than I think any of us anticipated pretty quickly. I guess I have a definitional question for you, and maybe you can answer this. Is it possible to be a victim of sex trafficking without a trafficker?
And Chairman Olson, Representative Wassett, I don't know that I have the answer to that question. I don't work in criminal law, which is where that determination would be. And perhaps Ms. Chambers can provide some additional information. But I do not have the answer to that question because I haven't reviewed our human trafficking laws.
Well, and Ms. Chambers, you can light up your camera. You might want to answer this question. I mean, I think it's in the bill. The bill says that is exactly Representative Yin's question. That we change the definition. So we say that a minor who engages in any commercial sex act is considered a victim of human trafficking. So to Representative Washington's point, even though there's not, they are themselves, I suppose, the trafficker in Representative Yin's question. Whether they are or not, I don't know. But by definition, it doesn't appear to need that third party or that other party to traffic. Ms. Chambers.
Chairman Olson, the definition of trafficking requires a third party. I am aware, and I think Ms. Markham did a very good job of explaining sort of the advocacy movement to remove the need for a trafficker. I candidly, and I feel like I'm in a terrible situation because I certainly don't want to say I understand everyone wants to protect children and to do the right thing. To me, every training I've ever gone to, all my legal training in human trafficking, that's the whole point, is that there's a third party. We have other existing laws to protect children and perpetrators, or buyers in other statutes. The human trafficking statutes were developed to go after this criminal enterprise, the fact that someone else is profiting off of the pain and suffering victimization of another, whether it's labor or sex trafficking. And so, yes, you need a trafficker. This bill attempts to change that, and that is a policy decision for the body. But me personally, and I don't mean this to come across as I don't have faith in what they're doing or I don't understand, but I don't personally understand, and I don't see a scenario. If there's not a trafficker, it's not trafficking. It's child abuse, it's sexual abuse, it's other criminal acts. But I don't know that it's necessarily trafficking. But again, I'm aware that this is a movement afoot in the field of child sex trafficking. To have this language, I think this is model language that is out there. But my personal opinion, and again, maybe I'm too close to it. I was involved in the crafting in 2013 when Wyoming drafted our original statutes. We were the 50th, as in dead last state in the nation to pass human trafficking laws. And while that may seem like that's a blight on us, it actually gave us the benefit of looking at other states, looking at other statutes and what worked, what didn't work. I think there are things that in the laws that we can change to beef up our response. I'm just going to very candidly say right now in our prostitution statutes, there's a huge gap that we attempted to address, but that bill didn't move because we have some certain acts that happen at massage parlors that aren't illegal in our state right now, and there's things that we can do to try to support law enforcement to crack down on these instances. But again, I don't understand how you have trafficking without a trafficker. That's, again, my personal opinion as someone who's worked on this issue very closely for 10 years.
All right. Thank you, Ms. Chambers. And thank you, thank you, Attorney General's office, for being so quick to find us folks to in jail for you to chime in. As an attorney, I know that we are often expected to have the answer on the fly, but as you know, it usually takes a lot of research before the hand and studying the language and making sure you know where all the statutes are and what jives. So just appreciate you on the spot being willing to answer some questions.
You're welcome.
Mr. Chairman,
Yes,
just have a question for Ms. Schilling, if that's okay.
sure.
Mr. Chairman, Ms. Schilling, I was wondering if you can just back up a little bit in regards to Chin's cases and talk about the efforts that are made in MDT meetings, the multidisciplinary team meetings that occur for that child, and kind of who those key players are to help in rehabilitation.
Ms. Schilling?
And Chairman Representative, if Jill is still available, I'm going to ask her to step in and give me a statutory citation for the MDT makeup. I know the MDTs are assigned through the court process, and there are mandatory members that are part of that makeup. I just don't have the specific reference with me right this second.
All right, on the spot again.
Representative, I am so present, and Ms. Schilling is correct. Our statutes require certain people as mandatory members of the MDT, and then there are other people who can be discretionary members of the MDT if the court appoints them. And I'm just flipping through to find that statute. It is 14.6.427 in the Chins Act. The mandatory members are the child's parents or guardian, a representative of the school district who has direct knowledge of the child, a representative of the Department of Family Services, which is typically the child's caseworker, the child's psychiatrist, psychologist, or mental health professional, the district or county attorney, the child's attorney or guardian ad litem, a volunteer lay advocate if one is appointed by the court, that would be a CASA, and the foster parent of the child. The child, him or herself, is a discretionary member, but can be appointed to the MDT as well as a relative of the child.
All right, thank you. All right, in the room, anyone wishing to testify on this bill? Gail.
Good morning, Mr. Chairman, members of the committee. My name is Gail Simmons. I am a resident of Sheridan County. I also am on the board of Compass Center for Families, and I volunteer as a court-appointed special advocate. That's just background information. I became involved with Uprising through meeting Terry Markham and some of her board, and had volunteered to provide some assistance on how you kind of work the legislative processes. I wanted to address, if you don't mind, on the requirement for a third party. That actually has been removed. So federal law, and I've asked for this for the reference. This bill was crafted around the existing federal statutes on anti-trafficking. And in federal statutes, they have removed the requirement for a third party. And most of the states have done that as well. So that's one of the primary reasons for this bill, is to align better with existing federal law. As it was pointed out, Wyoming is playing catch up. We're playing catch up on the laws. We're playing catch up on the victims' services. So I wanted to point that out, and then just kind of.
And Gail, on that one, I was going to ask Ms. Chambers when she said that, when she said, of course, you have to have a trafficker. I was going to ask her for the statutory citation. Is it possible? If someone to just email us the federal statute that we're talking about. I don't know if there's multiple statutes, but it seems like that would be helpful if we could see that language. So we know, okay, now this is what we're mirroring it to.
Yes, Chairman Olson. I just had a quick chat with Terry Markham and asked her to find that. Okay. So as soon as we get that, we'll make sure that it is sent out to the members of the committee. Because I think it's really important to realize that because of I-80 and to some extent I-90 and I-25, we are in a position on many areas, not just trafficking, where interstate commerce becomes a factor, and therefore, to a point that was made earlier, we may not have things that get prosecuted in the state, but because of pass-through, we're able to put it to the feds. But we can't guarantee that. So we want to make sure that we're in line. So I just wanted to summarize the three main reasons for this bill. It helps minors who cannot legally consent to a commercial sex act as victims of human trafficking, even without a third party. Often the needs of some victims are so great, they engage in commercial sex without that third party. They're still victims. The second one, seeing minors that do not identify at that time as who their traffickers are, or even recognize that they themselves are victims and have been exploited. And so the state has an interest in providing support on that. So they need to have access to services as a victim. I spoke with one attorney about the fact that there was recently a case in Ohio where they busted a ring and they charged the victims with prostitution. And I asked about that and was told it was not that they wanted to criminally charge them, but that was the only way to get them access to the services that they need and to take them out of the reach of their traffickers. So part of this is to remove those victims from the legal system and put them into the system that will serve them best. And then third, whether they are identified, self-identified or other as self-trafficking, it would actually recognize that minors engaged in commercial sex with these changes are not child abuse, but child neglect, for purposes of providing care, protection, and services. So this bill is really about how do we get these victims to the correct support that they need. And I think that everyone would be appalled at the degree to which this occurs, not just to the victim who spoke from being in Casper, but throughout the state. It is too easy to fall under the covers, so to speak. And I stand for questions.
Vice Chairman Washit.
Thank you, Mr. Chairman. I sure appreciate you being here today. What I'm wanting to avoid, because we're dealing with teenage underdeveloped brains, as the testimony has indicated. I don't want to send a message that gets misinterpreted that prostitution among teenagers at the local high school is now legal in Wyoming. Okay, that's the message I don't want to go out. And so even though we have these other laws out there that we can use because minors can't legally consent to commercial sex activity, that's my worry. So any response on that, I'd appreciate.
Gail.
Mr. Chairman, Representative Washit, I don't think any law that I've ever listened to be proposed down here is capable of covering every particular instance. You need to have it be so that it accomplishes what you intend to have it and allows for how do you deal with those exceptions. In this particular case, I think prosecutorial, discretion, thank you. And I presume that our prosecutors have discretion. But anyway, that capability is really what has to be applied in these cases, because you cannot know every single circumstances surrounding these. So if a shall has to be changed to a may in order to reinforce that discretion, I think that would be great. I think there's nothing in here that would stop a minor who is the aggressor, the coercer, the individual who causes this to happen. I'm not a lawyer, but I didn't see anything here that would prevent the victimizer from having particular sanctions.
Yeah, follow up.
Just quickly, I get that when we have that third party aggressor, but in the self-trafficking situation, that's what I'm trying to avoid, is that young people get this idea that they can supplement their income by doing sexual things on their own without being coerced or cajoled or victimized by a third party, but they self-traffic. And the word gets out among the high school that, hey, prostitution's legal for minors in Wyoming. And that's a message I don't want to get out.
Yeah.
Mr. Chairman, as has been pointed out, minors legally cannot consent to commercial sex, whether they are deciding to do this themselves or somebody else is. And the question becomes, if a 17-year-old of either sex decides to sell their sexual services for whatever reason, whether it is for money or a place to stay or food, I do not believe that legally that's okay. So it still is an illegal act. They still need that intervention, and maybe the ones who are in such a place that they are so vulnerable that they believe that this is the right option for them, they may be the ones who need these services the most. And so it's those that we need to capture, as well as those that are victimized by somebody else.
Representatives Wanser?
And thanks. It might be a rhetorical question, or maybe not the right person, but it's based on what you said on. So here's my issue is you can't be considered a perpetrator of a commercial sex act if you're a minor, but this bill says you can be a victim. I mean, that's really what we're saying is you are considered a victim of human trafficking for what I would normally consider exploitation. And maybe it's just because I helped write the Sex Trafficking Act, 7 years ago. And when I think of sex trafficking, I think of something over here. I don't think of when we're talking about 17-year-olds doing weird things and commercial sex acts. Commercial sex act is pretty broad in our definitions. And the ultimate goal is to get them into some type of services and treatment and counseling. But to do that, we're basically making the law say they're a victim of human trafficking, not a victim of exploitation, a victim of, it already allows them to be a victim of abuse or neglect. I just can't, I'm missing the dichotomy of you can't have a minor ever be a perpetrator of a commercial sex act, but they are now going to let them be victims. I'm not there. Can you help me out?
Yeah.
Mr. Chairman, Representative Swanitzer, the fact that most of us have this real well boxed in idea of what constitutes trafficking is precisely why this bill has been created. Because we have this idea that it is a ring or requires a pimp, and that is not correct. So it goes well beyond that to the instances that the examples that you've provided. So by defining as victim services, so trying to get somebody to victim services if they are not identified as a victim is a hole in our approach that needs to be closed. So that whole idea of deeming them victims is part of the way in which that third party no longer becomes part of it. So we're separating any act by a third party and what is legal or what can be done about them from the victim and what we can do for that victim.
And Gail, just to Representative Swanser's question, and to your response, couldn't you just call them a victim of something else? Couldn't you just call them a victim of sexual exploitation? Why didn't we just write a bill that said that instead of human trafficking? Wouldn't that have solved the problem too?
Mr. Chairman, I expect that it could. And if the committee does decide not to move this particular bill forward, I will put in a request for an interim topic, because I think that the initial work that was done around sex trafficking that Representative Swanitzer was working on, and the work that is being done through Uprising and some of the other services, that it could all be addressed as a whole. And so when looking at child exploitation, sexual trafficking of a minor, that rather than piecemeal, which I think happens when you have bills that can only have one topic, that an interim topic may be the right way to go if you decide not to move this forward. It does need to be addressed. Those victims are being left out there, and we do need to provide the capabilities of our services to be employed to them, and for individuals who don't realize they need help to get the help that they do need.
I think that's right, Gail. And I think everyone on this committee appreciates the reality of what the ultimate goal is, which is to get services to a victim. And I think everyone understands the reality is it's not really about whether you prosecute or don't prosecute the victim, because that doesn't happen in Wyoming. Our prosecutors know better. They're better than that. But I think that I think it's just about getting it right in terms of what we call it. And I appreciate where we're attempting to head with it, but I just think of a million scenarios, and maybe seeing that federal statute is, I think, going to be helpful for the committee. But I don't know that it necessarily has to be an interim topic, but the hour draws late on the session, today being the last day to get a House bill out of my committee. I think, if we had more time, we could just substitute build this for the right definition where we want to plug it in. But, I guess the committee will sort that out. I don't know that it's the end of the world that we change what we call human trafficking to not have a trafficker. I don't know where it necessarily has to fit, but I think these are good questions. Vice Chairman Washut.
Thank you, Mr. Chairman. The existing statute, as it reads here, says that we can classify these individuals as chins or neglected. Does that not open the door sufficiently for services? They have to be abused in order to receive services, or does existing statute with neglected and chins give DFS that opportunity?
Mr. Chairman. Through you. Representative Washut, I believe that because it requires the county attorney to initiate the chins, I think that the concern is providing that information and ensuring that it gets to those county attorneys, because it's not DFS who initiates the chins. I don't have a direct answer for you, but I believe that that's another place where there is a gap in trying to initiate the chins.
All right. Thanks, Gail.
Thank you.
Further public testimony in the room on House Bill 210. Anyone wishing to testify on this bill? All right.
Mr. Chairman,
Further testimony in the virtual world.
Ms. Chambers has raised her hand again.
All right. Ms. Chambers, give you a 10th crack at the apple.
I'm sorry. I just want everyone to be very clear that these individuals do receive services as victims. They are identified as a victim through a variety of mechanisms. The existing statute does clarify that that this opens up compensation eligibility, et cetera, et cetera. I couldn't let that go, that people thought that there somehow that we're not serving these victims. We also serve federal victims because there is no federal compensation. So I just couldn't let it go. I apologize.
Appreciate you. Thank you, Ms. Chambers. All right, I'll close public comment on this bill. Committee, what is your pleasure on the bill? Moved by Representative Larson. Seconded by Representative Williams. That might be your first second of the session. Congratulations. That might be your first move of the session. Congratulations. All right. Discussion on the bill. Discussion on the bill. Amendments on the, are you going to discuss or amend?
Discuss.
All right.
I do think an amendment will be needed, but I don't have language or anything prepared at this point. As I said earlier, I am very concerned that by making prostitution only apply to people 18 years and older, that can be misinterpreted, misconstrued, and might invite additional commercial sex, legal or it would be illegal, but among teenagers in our high schools. And I certainly don't want that to be the interpretation that comes out of this. So I think the bill will need some work on second reading.
Representative Washut, have you seen how many bills we have on general file and how many days we have left? If you have an amendment, I would sure love it.
I'll try.
Okay.
On page 2, delete lines 19 through 23, and on page 3, delete lines 1 through 6.
Okay. Page 2, 3, starting on page 2, delete. So you're deleting 6-4-101.
Exactly.
Second, is there a second? Seconded by Representative Larson. Representative Washut,
I think I'm getting a friendly over there.
a friendly from Representative Oakley. Oakley's working on it. And take just a second. Why don't you speak to it a little bit?
I will. It's not my intent to delete 64101 out of statute, but out of this bill. So and if we have to rephrase it in order to accomplish that. So I want to maintain prostitution as a crime. Because we heard testimony that nobody prosecutes minors for prostitution in Wyoming. And so whether it states that or not, it just doesn't happen in Wyoming. But what that doesn't do is give this possible perception that we've now somehow legalized prostitution for minors.
Representative Larson.
Mr. Chamber, wow. Mr. Chairman.
I hope Miss Olson is not tuning in right now.
Trying to get chairman out. Woo. I wonder if we could do a friendly amendment on that and just delete the new language.
Delete the on page 22, or sorry, page 2, line 22.
Line 22, correct.
Yeah. I think that would make sure we don't delete the statute.
Yeah.
Correct.
Okay. It's a good friendly.
And I accept it.
Representative Craigo.
Discussion, Mr. Chairman. So I understand what the amendment's intending to do, but without changing the language on lines 5 through 9 on page 2, we haven't accomplished anything by the amendment, because that language still says that a minor who engages in any commercial sex act shall be considered a victim, which means we cannot prosecute them under the statute anyways.
Discussion on that.
Yeah, please, Representative Oakley.
Thank you, Mr. Chair. So the question then becomes, for the next amendment is, are we talking about removing that language or changing it for a rebuttable presumption, or neither?
Mr. Chairman.
Representative Yin.
Thank you, Mr. Chairman. So for discussion, my concern here is if the intent of the bill is to help children get services, I don't understand why we would still include them as possible for prosecution at the same time. So for me, I think it goes against the intent of the bill to strike that language. So I don't think it's a good idea to strike it. Thank you.
Representative Washut.
So if we were to extend my amendment to also include on line 8, page 2, inserting a period after the word prosecuted and striking all the remaining language on 8 and 9. So that we would have a minor who engages in any commercial sex act shall be considered a victim of human trafficking, regardless of whether the minor's offender is identified or prosecuted, period.
Well, the second okay with adding to this amendment, so we don't have to, maybe it's easier just to dispose of it as once. Okay,
No, I'm good.
all right. Representative Craigo.
Back to my, Mr. Chairman, sorry, thank you. Back to my initial comment, we can do that, but if we read that sentence with the sentence directly in front of it, at the beginning, starting at line 1, We are saying they cannot be criminally liable for any commercial sex act. So my point is if we take out the language down below and we take out the language just proposed, we've essentially, we're legislating against ourselves. And then I would propose to you or to the committee that we're getting the purpose of the bill. And if that's what we do, then we should just vote down the bill. Thank you, Mr. Chairman.
I withdraw my amendment.
I agree. We did get the discussion.
That was a fun exercise. Appreciate that. Okay, so maybe there are amendments on second reading. Maybe there aren't. But there's no more amendments today, I assume. Oh, Representative Williams. Oh, you want to we almost forgot about your amendment, John. Okay. Moved by Representative Williams and seconded by Representative Washit. Any discussion on this amendment? Question on this amendment? All those in favor signify by raising your hand. All those opposed, that amendment is adopted. Any other amendments or discussion on this bill? Seeing none, Kate, please call the roll on House Bill 210. Oh, you reached for your mic. You're just getting ready to vote. I'm sorry. I just want to make sure I didn't cut you off, Representative. Okay, please call the roll, Kay, on House Bill 210.
Okay. Representative Crago,
Aye.
Representative Larson,
Aye.
Representative Oakley,
No.
Representative Provenza.
No.
I'm sorry,
No.
Representative Williams,
Aye.
Vice Chairman Washit,
No.
Representative Yin,
No.
Representative Swanitzer has voted aye.
Hmm.
Chairman Olson.
Wow, thank you, committee. Aye.
Mr. Chairman, you have 5 ayes. You have 4 noes. The noes being Representative Oakley, Representative Provenza, Vice Chairman Washit, and Representative Yin. Is that correct, committee?
All right.
Thank you.
Representative Bear, maybe be thinking about working with your group and thinking about some amendments.
Yes, sir. And thank you to the committee. And sorry this took so long. I didn't think it was going to turn into that, but I appreciate all your work on it.
The Judiciary Committee. We like to do one bill at a time. Thank you.
By the way, Mr. Chairman, the appropriate code is 18 U.S. Code 1590 for this bill.
Can you email that to us?
I will.
Thank you. Senator Nethercott. Senator, which bill would you like to do first? Did you say my agenda is whatever my agenda is? I just want to, if you think there's an easier bill to process through in 30 minutes, I'd be happy to switch the order, but
Mr. Chairman, I have Detective Wilmarth here to speak on the bill from the Cheyenne Police Department. He is a busy fellow working on child human trafficking issues as well. So he is here this morning. So in order to be respectful of his time, I'd like to do Senate File 101 because he can speak to that particular bill.
You got it.
Mr. Chairman, with your permission, may I allow Detective Wilmarth to sit at the table?
Sure.
For the help with time efficiency this morning. Mr. Chairman, may I proceed? Good morning, House Judiciary Committee. It's great to see you. We're over in Senate Judiciary Committee, I think, flipping over bills and committee members. So it's a busy Friday morning. In front of you, you have PIN registers and trap and trace devices authorization. I think it's fun to say trap and trace device 3 times fast. We do it in the Senate sometimes. What is a trap and trace device? What is a PIN register? I'm sure many of you on the committee may know, might have experience with using these devices. What they are is they are technology devices that have been around for decades that allow for the ability to determine which phone number is calling another phone number. That's it. They do not allow, and I really want to impress this fact upon you because I don't want to overcomplicate the issues. It does not allow for the determination of what's being communicated. So you can't hear the conversation, you can't see the conversation. It only reveals the information of the telephone numbers, which telephone number is communicating with another telephone number. Again, this type of investigative tool for law enforcement has been around for many, many, many years in this country. In Wyoming, we brought it into our laws in the 70s when we created the Division of Criminal Investigation as part of the need for Wyoming to really focus its efforts on drug trafficking and the influence of drug trafficking in the country and in Wyoming. And so as part of that, we stood up the ability for law enforcement with the authorization and cooperation and through the county prosecutor or district attorney to obtain authorization with probable cause approved by a judge to use one of these devices for only drug crimes. So we allow this and have allowed it for the last 40 some years now, because that's when the 70s was, for drug crimes. I have been approached by law enforcement and recognized the need for continued tools for law enforcement to do these types of investigations, but recognizing the need to expand that beyond drug crimes to violent crimes, right, into serious felonies. That makes sense that law enforcement has those tools in its toolbox to investigate crimes like human trafficking, which frequently and commonly use technology and phones as part of rings and conspiracies. Very hard to human traffic by yourself as an investigative tool. So kind of dovetailing into your previous conversation and where you've been. So this bill expands the authority from its limitation to just drug crimes to serious crimes or violent crimes. Stand for questions. Excellent.
Senator,
Excellent. I don't know if it's good or bad or.
Senator, the blue bill and the white bill.
There isn't a
show me the change is you removed threatened from the definition of crime of violence. Is that what I see?
Mr. Chairman, no, there is an engrossed version of your bill. Looks like you all have that in your packets. That's great. That blue one. Threatened property crimes. So the bill originally had in it, we expanding the scope to felonies, and included in felonies is property crimes. So the Senate determined that they didn't want to expand the scope to include kind of violent crimes and exclude property crimes essentially from the bill. And so the language before said was in reference to or the threat of property crimes. I think the work that the Senate did was good. So no concerns there.
Representative Provenza.
Thank you, Mr. Chairman, and Senator Nethercott. Thank you for being here. I have a question about the definition of crime of violence. It includes any offense that has an element, the use or attempted use of physical force. I just want to make sure I understand kind of what we're trying to encompass in this definition, and that because it seems like this is pretty broad. So what exactly are we accomplishing with this through this definition with these attempted use and any offense? Thank you.
Thank you, Mr. Chairman. Representative Provenza, great question. So this is unique. So typically when we're looking at developing criminal statutes or discussing crimes, the act has already been committed and we are punishing the actor and approaching the crime from the back end. This is approaching the crime from the front end and really trying to either prevent or solve a crime. And so this is an investigative tool. And so this allows law enforcement to investigate a crime that may be occurring or may occur. So when we think about potentially an issue of domestic violence or stalking or another type of threat of attempted violence, it may not have happened yet, but there's a significant threat that it will. Law enforcement needs to access that information as quickly as possible to prevent the crime from occurring. And so unique here when we talk about attempt and where this particular statute falls in the criminal code, which is really an investigative tool to prevent or respond to crime.
Mr. Chairman, Senator Northcott, I always appreciate senators in this side of the building. So question for you is, what are pen register laws like in other states? And do they also include crimes of violence? Or are they generally restricted to drug crimes? Thank you.
Mr. Chairman, through you, Representative Yen, most of them are felonies. Yes. Great question. They are expanding beyond that. Most do have limitations similar to what the Senate amended out to really focus it in on those really serious crimes. The policy question for you is to expand it beyond drug crimes. And I think it's more than appropriate to do that, to prioritize people over drug crimes, particularly with where we are and many of, this body recently reviewed and heard on the legalization or decriminalization of some of our drug crimes, that where we are today is not where we were in the 70s, and really prioritizing people in our criminal code over drugs. Not that those aren't important too, but.
Sorry, did you say not that drugs aren't important too, or?
I think it's fair to say that much
joke.
of the drug trade is
It was a
harmful to
joke,
people
Senator.
as well and has a very negative impact. Typically, you find the drug trade and drug traffickers associated with human trafficking as well, and they go hand in hand. That aside, I do think it's an appropriate policy statement for the legislature to expand this authority for the protection of people.
Vice Chairman Washington.
Thank you, Mr. Chairman. Obviously, I like the bill and will be supporting it, but I guess I'm a little disappointed that conspiracies that might go beyond violent crime. In my career, I know we had lots of burglaries and thefts and all sorts of things where you had fences and a lot of property criminals who were working in concert with one another, where a pen register might have helped us put that conspiracy together. So if you're, would you be opposed if we were to reinsert property crimes into this bill? Would that cause more difficulties than good?
Mr. Chairman, through you, Representative Washington, we speak the same language. Unfortunately, the Senate has much higher, they don't trust the system as much, or maybe understand the level of work that goes into these types of investigative tools and the level of review. And so they are much more cautious about expanding that scope. And so I think it could cause challenges, particularly with the short time frame we're all under.
Thank you, Mr. Chair. Thank you, Senator Nethercott. So just quickly to that point, it does have for a felony, right? I mean, so it's not exclusive of, I'm not exactly sure, and I should be, but what was taken out, but this wouldn't exclude, like he mentioned, burglary, because burglary is a felony. Was that accurate?
Mr. Chairman, through you, Representative Oakley, I think that argument could be made.
Thank you, Mr. Chairman. And this is just a clarification, I think, for people watching. In 7-3-802, we do require a warrant, right? So there is not going to be any just probable cause allowing for these tracers, right?
Mr. Chairman, through you, the standard for obtaining a warrant is probable cause. So it's the same standard for getting a warrant, but this is not considered a warrant in the same sense, but it's the same standard. So I think it's essentially 6 of one, half a dozen of the other for the judge's review. Mr. Chairman, if I may, the Senate debated heavily, as we historically do, the Fourth Amendment. And the Fourth Amendment is alive and well for unreasonable searches and seizures. Our judges are trained, our prosecutors are trained, defense attorneys are, have acute sense of the Fourth Amendment as well and quick to use it as a defense. And so I would just remind the committee that that is the ultimate safeguard. That is the standard for all of the lawyers involved in the process who are stark defenders of our constitutional rights on both sides in the criminal justice system, and notably the judges who make the review of this. And so just be mindful of those considerations.
You want to introduce us to your witness?
Mr. Chairman, yes, this is one of Cheyenne's finest, Detective Wilmarth, who has been with the Cheyenne PD for many, many years and is a skilled investigator and obvious detective and has hands-on experience with these devices and with these investigative tools, and recognizes the challenges and the failures of our laws to effectively investigate some of the crimes that we're experiencing here in Wyoming. So with that, I'll turn it over to Detective Wilmarth.
Welcome, Detective.
Good morning, Mr. Chairman, representatives of the committee. Just not to try to bolster myself too much, but to give you an idea of my investigative experience. I have been a police officer with Cheyenne Police Department for more than 15 years now. During that time, I've worked in the patrol division and spent the majority of my career in the detective division. I've worked narcotics, I've worked property crimes, and currently I investigate high-tech crimes, primarily focusing on computer forensics. Through this, like the good senator said, I have seen some of the failures in our laws, and that would be why I did reach out to the good senator and ask her to draft a bill addressing these failures. Specifically, when we are doing crimes and we're looking to address the conspiracies, as Representative Washa had stated, we often look to phone records and other records where we can identify actors in the conspiracies and people who the suspects may go to. This bill does not give us any more access to the records that we would already be able to get, just in a different time frame. The trap and trace pin register devices are a live time frame, whereas we could go to a judge every day and just be behind the 8 ball by 24 hours, and the processing time for records that we would be looking for in these types of investigations. One of the biggest needs I see for in this very proactive investigation tool is from cases that we have seen specifically here in Cheyenne, where we do know phone numbers of suspects, specifically in homicides, where we have identified the suspect, we've identified their phone number, and we know that they are using their phone. We just don't know who they're calling, where they may be going to. Those investigative tools that where if we see the numbers that are coming in or going out of their phones, that we can use our tools to try to identify who those people are. If they're calling people out of state and they may be fleeing the state, if they're calling people who we have records for telephone numbers, and we can identify where their safe haven is and where they're going. We've had multiple homicides where a tool like this, if we were able to get an application in front of a judge right away and get this tool up and running, we might be able to more quickly apprehend that violent felon who had just committed a homicide. And sometimes we have those people, they're out on the lam for multiple days, and we're investigating hundreds of hours of manpower in just a matter of days, just trying to identify who these people know. If we're able to identify this stuff right away, we can really hone in on our investigation and identify who they're in contact with, where they may be able to go. Another case that we had was an Amber Alert, where we had a very young child taken by the mother's boyfriend here in Cheyenne. Again, in an instance like that, we're looking for where that person may be going. So we're trying to access those phones, who they're calling, where they're going to go. That person did end up going out of state, and thanks to some good investigative work, we were able to locate them in Aurora with a family member. But many, many, many hours later, however, had we been able to get this in front of a judge and to the telephone carrier right away, we would have been able to ensure that was done in a much quicker fashion. And then the last example that I want to provide is, as the good senator had mentioned, a stalking case. We did have a stalking case recently where we knew the actor was an extreme threat to the ex-wife, including displaying of weapons and making threats. However, that person had left the residence and we had no idea where they were, where their safe haven was. Again, so if we're able to find out who these people are in contact with in real time, we're able to better hone our investigations and keep our communities safe. And that is the big purpose of the bill. We are able to wiretap and continue to wiretap and listen to the communications of bad actors for murder, blackmail, felony property theft, burglary, those types of crimes. But unless it is solely a drug crime, including a misdemeanor drug crime, we can't see those real-time communications as they occur. This is not a tool that is going to be widely used. They are cost prohibitive, but if you have that correct case, the homicide, the Amber Alert, the person who is in danger of the domestic violence stalking who will turn into a homicide victim if you're not proactive, this is when law enforcement will expend those funds to ensure that we can be proactive, investigate this, and keep our communities safe. And then one thing that I think should be very stressed, and the good senator did mention this, the Supreme Court has stressed how limited is the information collected by PIN registers. Quote, neither the purport or any of the communications between the caller and the recipient of the call, their identities, nor whether the call was even completed is disclosed by a PIN register. This is just information, telephone records in real time. These are the same records, again, that I can go to a judge and ask for after the crime has occurred. We are looking for it in real time to ensure that we are keeping our communities safe and being able to apprehend these extremely violent individuals.
Representative Washington.
Thank you, Mr. Chairman. So in page 3, thank you for your testimony today, Detective. Appreciate that. On page 3, lines 11 to 13, for use in the apprehension of a person for whom there's probable cause that a person is arrested for a felony or a crime or violence. This really sounds like a fugitive apprehension limitation. You're not going to be able to use this for identifying ongoing conspiracies of other felonies such as burglary and fencing operations, but this is for the apprehension of someone who you already have probable cause to believe committed the crime of violence. So this is a fairly limited law. I support it, and I vote today.
Detective, are you still a president of the Cheyenne Police Protective Association, or have you rolled that over? Okay.
Yes, sir. At least for the rest of this year. We'll see what the next term brings.
Well, thank you for your service.
Thank you, sir.
And good choice in tie today as well.
Thank you, sir.
All right. No further questions? All right. Cool. Thanks, Senator. We'll finish out the rest of this public comment. I do have Terry. I got one online, so let me let him bring them on in. All right, Terry, you're on deck. Go ahead and turn on your camera if you'd like and introduce yourself and share with us your comments.
Thank you, Chairman Olson. For the record, my name is Terry Armitage. I'm with the Wyoming Sheriffs and Chiefs Association. And I simply wanted to speak in support of this bill and hope that the committee will give it its favorable consideration. Thank you.
That was very concise. Appreciate that. Questions? Committee? No? Thank you, Terry.
Thank you.
All right, anyone else in the virtual world wishing to testify on this bill? Raise your little hand if you want to come on in. How about in the room? Anyone in the room wishing to testify on this bill? Okay. Got any final words for us, Senator?
And appreciate your support and I votes. Thank you.
All right, I'll close public comment on the bill. Committee, what is your pleasure? Moved by Representative Washit. Representative Ian, you're a co-sponsor, aren't you? You want to give it to Representative Oakley? Is that your first? That's not your first, second. Okay. Yeah.
Thank you, Mr. Chair. It seems to me that the word "of" needs added in page 2, line 3. Crime of violence means any offense that has an element, the use. I think that has an element of the use, or so. This is kind of a clerical.
So it reads, means any offense that has an element, the use or attempted use of physical force against another person.
Needs of in there, right?
I think the of follows after use in between physical, which applies to
Has an element, the use or attempted use.
Senator.
Mr. Chairman, use the committee's wisdom there for what makes sense. May want to check with LSO if it looks like it's a technical error as opposed to a written error. May not need an amendment, may not need to take it back to conference. So just be careful of that.
Okay. Well, if it does, I think rather than send it to conference, I think we can do a technical amendment on the floor. I'll just do a technical amendment. If not, pick it up in the reviser's bill probably. Right? Okay. All right. Very good. This bill won't turn purple. All right. Any other discussion or amendments on this bill? All right. Kay, will you please call the roll on Senate File 101?
Representative Crago,
Aye.
Representative Larson,
No.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Williams, Vice Chairman Washit,
Aye.
Representative Yin,
Aye.
Representative Swanitzer. Oh, I'm sorry. Representative Swanitzer has voted aye. I'm sorry, Representative Yin. Aye, thank you. And Chairman Olson.
Aye.
Chairman Olson, we have 7 ayes and 2 noes. The 2 noes being Representative Larson and Representative Provenza.
Okay, thank you. And Senator, I suspect we can't get through Senate File 124 in 2 minutes. So do you have a noon meeting? No. Okay, we do. So we'll carry this over to our noon meeting and we'll see you upon recess.